And I welcome this bill, which is a very short bill. I think, depending on how you count it, I think there are 4 pages, 7 sections, and the principal purpose has been outlined frequently here today, to provide for an increase in the maximum number of judges. I very much welcome that. I think it's very positive. However, it's following ongoing and serious concerns from just about every, from the Chief Justice, the High Court presidents, other courts, organisations on the ground in relation to the serious lack of judges, and that leading to backlogs and ever-lengthening waiting lists. It's a piece of legislation that's based on a very comprehensive report, which I've read and looked at, and I'll come back to the theme that keeps recurring in that report: the lack of judges, consequently failure to provide an efficient court system, but also the interlinked changes that are necessary, not to mention access to justice, which will not be served completely by the increase in judges, but needs other fundamental changes as well. I want to thank the Digest for producing, once again, under pressure, the Digest for us, which they do repeatedly under pressure, and I think it's something we should look at, how they are constantly have to produce papers for us under pressure and at the last minute. The lack of judges in Ireland has been the subject of significant criticism, as I've just said, and has been the single biggest thing, it was said, that the Oireachtas could do to improve the quality of justice is to legislate to provide for additional judicial posts, which we're finally doing. The current President of the High Court has already been mentioned. Mr. Justice David Barneville has called for an increase in the number of High Court judges to address the volume of cases coming before, and indeed the complexity of cases, which has been pointed out in the report on more than one occasion, and they've cited the Assisted Decision-Making Capacity Bill as one example, 2015 to 22, 7 years, and the complexity of that bill and the consequences for the number of staff needed and judges to deal with that, if we're serious about it, having taken 7 years to get that far. The former President of the High Court, Justice Mary Irvine, on a number of occasions called for additional judges. And the number of judges increased in 21 by 5. She said the increase was insufficient. She didn't spare us. She told us bluntly what was necessary. She indicated that the additional 5 judges were already accounted for at that time, and she described the current situation as desperate. We have also been subjected to criticism from the European Convention, the Court, and from various other bodies. So here we are again. And I welcome it, Minister, I welcome your work and I welcome the Department's work. We are here finally making provision for additional judges. And of course, that report that's before me here was based or worked along with the report from the OECD that showed the huge gaps if you compare our country with other countries, and they do point out that it's difficult to make comparisons. And if we look at, I'm awake, Thomas, it's okay. You're not, okay. If you look at the English system and the use of magistrates and so on, but notwithstanding all those differences, we're way behind, and all of the statistics have been set out. I think I'd like to go back a little bit on access to justice, and the increase in judge numbers is certainly very welcome, and it will help in that area of improving access to justice. But it's only one little part of access to justice that we're finally doing now, and we're going to do it on a phased basis. And again, I understand that, because a bit like housing, we've created a mess. We've left so many gaps in relation to the positions that we can only now do it on a phased basis, because of course, when you appoint an additional judge, you must also have a team. I declare a conflict of interest here because somebody very close to me works in that area, but there's a whole team, judicial assistants, registrars, and lots of other ancillary help that's also required. So we do it on a phased basis. It has been a theme of repeated public contributions by the Chief Justices over the years in relation to the consequences of the lack of judges, and also the imbalance in power in relation to people who have money and wealth who can access law through the courts, and those who haven't, and they've repeatedly highlighted that. And I think that's significant, and it's something I might come back to if I have the time, in relation to the role that judges have performed for us. And on occasions I can be quite critical of judgments that come down, but by and large, and given the restricted background from which they have come and the restricted schooling from which they've come, they have nevertheless served us well. And they've come out with judgments that have been particularly critical of the government, particularly in the areas of environment, which I'll come back to. And without them, I don't know where we would be actually without them, notwithstanding all of the problems surrounding access to justice. The Chief Justice, the current Chief Justice, welcomes this and says it's the first evidence-based attempt to assess the demand for judges on an objective and measurable basis, and obviously that's very important. He says it's a real and tangible recognition of the fact that a functioning justice system is not a luxury, but is a critical component of a modern, liberal, democratic society which is founded on the rule of law. And then he goes on to point out that that's not enough either, because people must know their rights in relation to access to justice. He said high-quality decision-making in courtrooms was not the sole objective. If people do not know their rights to begin with, they cannot get a hearing, or if they cannot get a hearing because of the delays in the system, if they cannot afford to go to court, if it's too expensive, as it is in many cases, notwithstanding the pro bono work done by various solicitors and barristers. The risk of an adverse order always is there before it. And so therefore the quality of justice isn't the quality that we should have. He also talks about the legal aid system, which I'll come back to, and I welcome the fact that there's a review of it finally. It's taken quite a long time to have a review of the legal aid system, and all of the restrictions under which that operated and the areas of law completely excluded from it are well known. And I hope that the review is an open and accountable review that looks to dealing with access to justice on every level, particularly in relation to the environment and climate change, not to mention the Labour Relations Commission and all of the other areas that are excluded, if we're seriously interested, Minister, in relation to access to justice. The previous Chief Justice is worth mentioning, Mr. Justice Frank Clark, who repeatedly returned to the barriers to access to justice, over and over, in a conference in October 21, and again the Chief Justice returned to it in a conference just last year, and set it out. I don't have the time, but I want to pay tribute to the fact that he has repeatedly highlighted the barriers to justice, one of which is the lack of judges, but all of the other barriers as well, where he talks about there are undoubtedly areas where the problem of access to justice can be particularly acute. Minorities, marginalised groups, or the vulnerable obviously run a real risk of having less effective access to justice than others. And he goes on to elaborate on that. And what's interesting for me, he talks about the moral need, the moral requirement, or the moral argument justifying access to justice, but also the practical argument that it's actually good for society, it's good for our economy, and he goes into that, and they had a special speaker at that. And the real consequence, of course, of not taking action is that we're going to be subject to repeated condemnation. Obviously, we've been there with the European Court of Human Rights and the Court of Justice. So all of those practical and serious consequences for not taking action. So today is a start in relation to that. If I can, in the last 6 minutes, I want to look at a narrative that has emerged repeatedly with this government and previous government, that objectors are causing the housing problem, or our objectors are stopping development. I think it's a very dangerous, disingenuous argument that's not justified at all. And I will say that by way of looking, and when we talk about the new planning legislation that's going to come before us, and we're going to restrict people's access to justice and people's access to taking a judicial review I think that's extremely dangerous, not based on any evidence, but simply a narrative that seeks to divert attention from whatever government is in power and their failure to deal with housing or with proper development or sustainable development. And I think, Minister, it's extremely dangerous, and I think it's something that has to stop. Government is doing it and various backbenchers are doing it about non-stop objections, which is not based on reality. I spent 17 years at local authority level. I saw people struggle to make reasoned submissions on planning applications against all the odds without being rewarded in any way, rather they were demonised. And there was a very good article by a solicitor back in November, and she highlights a lot of this. And she showed in a recent study by the Community Law and Mediation and Dublin City University, representatives of vulnerable and marginalised groups, for example, travellers, migrants, older people, reported feeling largely excluded from environment and planning decision making, and makes the important point, in the midst of a climate crisis and a biodiversity crisis, members of the public and NGOs should be empowered to fight for clean, healthy and livable communities. Access to justice should be strengthened and promoted. And she points out the entire process in talking about change has been overshadowed by a troubling narrative driven by members of the government and the construction lobby. And of course, she highlights the Aarhus Convention, which has been highlighted repeatedly in our courts, Minister, and you're more aware of this than I am, and repeatedly have highlighted the trinity of people involved in any planning application: the developer, the local authority, and the public, who have a vital role to play in making sustainable submissions in relation to any given planning application. So I'm just going to very quickly look at the burden, what we owe various groups that have taken it upon themselves to go to court with all the problems and all the risks that they've taken on. The Galway Ring Road went to the Bord Pleanála. Bord Pleanála granted permission for it, challenged, and that decision was quashed. Why? Because Bord Pleanála, the highest planning body in this country, failed to take on board the relevant climate action plan. They weren't aware that an action plan had been passed by the government 4 days before they made their decision. Seemingly they weren't aware of all the other climate legislation or obligations either. And again, we're thankful to a group on the ground who took that case. In relation to going back to the climate mitigation plan back in, I think it was 17, no, actually it was 20, the 31st of July, which seems to be a significant date every year because that was the same one in relation to the Sprat, which I'll come to in a minute. And the Friends of the Environment challenged the government, and the government, the plan, the mitigation plan, this was in 20, after we declared a climate emergency and a biodiversity emergency, the High Court determined that the government's national mitigation plan did not comply with the requirements of the underlying legislation. Why? Vagueness, lack of specificity, and that the citizen was entitled to know what the law was saying, and that didn't happen in that case. There have been many other cases. I mentioned the Sprat case, which is particularly important. The government did everything right on this occasion and brought in a policy to stop large vessels over 18 metres going into inland waters to fish unsustainably. They gave a lead-in period in relation to the Sprat. Two people, as were their right, challenged that and took a case. Except we're now 3-4 years later. They were found successful on one specific area, that consultation with Europe and with England hadn't taken place. So that policy was set at naught. What point am I making? The fact that it took so long in the courts. There seemed to be no urgency either on the part of the government to make a case that this was extremely important for sustainability in terms of our fishing stock and for farmers, for fishermen. No case was made at all, it would seem. And again, ordinary people are bringing it to our attention on a constant basis. I'm going to conclude by saying, if this is the start of seriously looking at making justice accessible to all, regardless of our means, then it's a good start. And I welcome it today. But this is only one tiny piece of the jigsaw, and the other pieces are there. We know that people do not have equal access to the courts. We know there are so many barriers, costs being one of them, and no provision in Irish law to allow for people to come together and take an action jointly. And that's really relevant when we look at, as I'm repeating it again, a climate emergency, a biodiversity emergency, a housing crisis, and a narrative repeated non-stop that the objectors are to blame, as opposed to listening what people at great trouble are telling us and at great cost, and using the courts as best they can in the most limited way. And we should be learning, Minister. Thank you.